I'll ask Lord Justice Nugee to give the first judgment.
This appeal from the Upper Tribunal Lands Chamber raises one short question. The appellant, Housing 35 Plus Ltd, which I will call H35, is a registered cooperative society which provides housing in numerous properties in Nottingham. The question is whether its rules are such to secure that all its management decisions are made by the members in general meeting, which I will call the statutory requirement. The significance of that is that if the answer is yes, it is common ground that its properties are exempt from the requirements of Part 2 of the Housing Act 2004, the 2004 Act, under which houses in multiple occupation, HMOs, are generally required to be licensed. The respondent, Nottingham City Council, which I will call Nottingham, took the view that H35's rules did not meet the statutory requirement and issued financial penalties against H35 under the 2004 Act for being in control of two properties that were HMOs without being licensed. H35 appealed to the First Tier Tribunal, the FTT, which allowed an appeal on the basis that the rules did meet the statutory requirement. Nottingham appealed to the Upper Tribunal, UT, who allowed Nottingham's appeal, concluding that H35's rules did not meet the statutory requirement. H35 now appeals to this court with the permission of Lady Justice Falk. We have had the benefit of able submissions this morning from Mr. Jonathan Manning, who appeared with Miss Poppy Henderson for H35, but we concluded after hearing from him that we did not need to hear from Mr. Andrew Lane, who appeared with Mr. Jeremy Ogilvie Harris for Nottingham, and informed the parties that the appeal would be dismissed. I now give my reasons for agreeing to this course. H35 is a fully mutual, non-profit housing cooperative. It is registered as a cooperative society under the Cooperative and Community Benefit Societies Act 2014. It was founded to provide housing, primarily for those over the age of 35, although it now also provides housing to students. It prioritises housing those who are homeless or at risk of homelessness. It operates numerous properties across Nottingham. The FTT heard evidence that it currently has between 75 and 80 properties with about 500 bed spaces. Two of its properties are at 27 Palin Street and 29 Eland Street. Nottingham took the view that these properties were HMOs for the purposes of Part 2 of the 2004 Act and hence required to be licensed. Part 2 provides for HMOs to be licensed by local authorities. See sections 55(1) and 2 and section 61(1). The latter provides every HMO to which this part applies must be licensed under this part unless A temporary exemption notice is in force in relation to it under section 62, or B, an interim or final management order is in force in relation to it under chapter 1 of part 4. Neither of those have any application. Subsection 2, a licence under this part is a licence authorising occupation of a house concerned by not more than a maximum number of households or persons specified in the licence. By section 72(1), a person commits an offence if he is a person having control of or managing an HMO, which is required to be licensed under this part, see section 61(1), but is not so licensed. Subsection 6 provides a person who commits an offence under subsection 1 or 2 is liable on summary conviction to a fine. Subsection 7A and 7B, which were inserted by the Housing and Planning Act 2016 with effect from the 6th of April 2017 provide as follows. 7a, see also section 249a, financial penalties as alternative to prosecution for certain housing offences in England. 7b, if a local housing authority has imposed a financial penalty on a person under section 249a in respect of conduct amounting to an offence under this section, the person may not be convicted of an offence under this section in respect of the conduct. Section 249a(1) provides the local housing authority may impose a financial penalty on a person if satisfied beyond reasonable doubt that the person's conduct amounts to a relevant housing offence of respective premises in England. Section 249a(2)(b) provides that relevant housing offence includes an offence under section 72. By section 249a(4), the amount of a financial penalty imposed under this section is to be determined by the local housing authority, but must not be more than £30,000. Nottingham took the view that H35 properties were required to be licensed, but were not, and so offences have been committed under section 72. On the 22nd of March 2023, it issued 2 financial penalties against H35, one in respect of each of Palin Street and Eland Street, in each case on the basis as set out in the final notices that, quotes, it is satisfied beyond reasonable doubt that your conduct amounts to a relevant offence in respect of premises in England, in that from 2nd October 2021 to 3rd August 2022 you had control of and or managed a house in multiple occupation, namely 27 Palin Street, with the address, which required a licence under Part 2 of the Housing Act 2004 and was not so licensed, contrary to section 72(1) of the Act, and a similar notice with slightly different dates was given in respect of Eland Street. In each case, the financial penalty imposed was £15,000. H35 appealed to the FTT. It took a number of points in its appeal, but one of them was that no offences had been committed because the properties were not HMOs as defined because of the provisions of Schedule 14 to the 2004 Act. The FTT heard that as a preliminary issue and, as already referred to, decided it in H35's favour. It is convenient to set out the relevant provisions of Schedule 14 now. Schedule 14 is headed Buildings which are not HMOs for purposes of this Act, excluding Part 1. Paragraph 1 provides, 1. The following paragraphs list buildings which are not houses in multiple occupation for any purposes of this Act other than those of Part 1. Paragraph 2 lists certain buildings controlled or managed by public sector bodies. And paragraph 2a, certain buildings which are social housing. Paragraph 2b, which was added by the Localism Act 2011 with effect from the 1st of April 2012, is headed Buildings controlled or managed by a co-operative society and reads as follows. 1. A building where a. the person managing or having control of it is a co-operative society whose rules are such as to secure that each of the conditions set out in subparagraph 2 is met, and b. no person who occupies premises in the building does so by virtue of an assured tenancy, a secure tenancy, or a protected tenancy. 2. The conditions are a. that membership of the society is restricted to persons who are occupiers or prospective occupiers of buildings managed or controlled by the society. b. that all management decisions of a society are made by the members, or a specified quorum of members, at a general meeting which all members are entitled to and invited to attend. C. that each member has equal voting rights at such a meeting. And D. that if a person occupies premises in the building and is not a member, that person is an occupier of the premises only as a result of sharing occupation of them with a member at the member's invitation. 3. For the purposes of subparagraph 1, cooperative society means a body that A. is registered as a cooperative society under the 2014 Act, or is a pre-commencement society within the meaning of that Act that meets the condition in section 22A1 of that Act, and B. is neither a non-profit registered provider of social housing nor registered as a social landlord under Part 1 of the Housing Act 1996. It is not disputed that H35 is a cooperative society within the meaning of subparagraph 3, nor that conditions 1b, 2a, 2c and 2d are all met. So the only question is whether the condition is 2b is met, that is, that its rules are such as to secure that, quotes, all management decisions of the society are made by the members or a specified quorum of members at a general meeting. It is not disputed that there are general meetings which all members are entitled to and invited to attend. I will come to its rules in due course, but to complete the narrative, the FTT Judge D. Jackson and Mr. A. McMurdo heard the appeal on the 26th of January 2024 and issued their decision on the 8th of February 2024. They allowed the appeal, deciding that H35's rules did meet the statutory requirement. Nottingham appealed to the UT. The appeal was heard by Judge Elizabeth Cooke on the 6th of November 2024, and she issued her decision at 2024 UK UT 349 LC on the 14th of November 2024. She concluded that H35's rules do not meet the statutory requirement as they provide for a management committee which is empowered to make management decisions, and hence not all management decisions have to be made by the members in general meeting. She therefore allowed the appeal and said in paragraph 49 of her decision, in conclusion, the appeal succeeds. That means that the buildings were HMOs and the matter is remitted to the FTT so that it can make a decision on the respondent's other 7 grounds of appeal from the financial penalties to the FTT. We were referred to a fair number of the rules of a society, starting with rules 1 to 3, which so far as relevant provide as follows. 1, the name of the cooperative shall be Housing 35 Plus Ltd, the cooperative. 2, the cooperative is registered under the provisions of the Cooperative Community Benefit Societies Act and is a cooperative housing association as defined by Section 5.2 of the Housing Act 1985, because these rules A. restrict membership to persons who are occupiers or prospective occupiers of the cooperative properties, and B. preclude the granting or assignment of the accommodation licence to persons other than members. 3. The objects of the cooperative shall be A. the provision, construction, conversion, improvement or management on not-for-profit cooperative principles as set out in the Appendix 1 to these rules of housing exclusively for occupation by members of the cooperative under the terms of a licence granted to them by the cooperative solely or jointly with another member or members, which shall, ... and then it sets out terms of licence and various other objects. That is sufficient to explain the general nature of the society's business. The key rules for present purposes are Rules 30, 48 and 69. Rule 30 provides the functions of ordinary general meetings shall be to discuss all management decisions of the cooperative that have arisen since the last general meeting. Rule 48, the cooperative shall have a management committee called the committee which shall control and direct the management of the day-to-day business of the cooperative in accordance with its objects and these rules. And Rule 69 provides as follows. The business of the cooperative should be conducted by the committee, which may exercise all such powers as may be exercised by the cooperative in accordance with its objects and these rules, and are not by these rules or by statute required to be exercised by the cooperative in general meeting. The committee shall in all things act for and in the name of the cooperative. Without prejudice to the general powers conferred on the committee by these rules, the committee may exercise the following powers: to A. Purchase, sell, build upon, lease, mortgage, or exchange any property or land, and to enter into any contracts and settle the terms of such contracts. B. Compromise, settle, conduct, enforce, or resist, either in a court of law or by arbitration, any suit, debt, liability, or claim by or against a cooperative. C. Determine from time to time the terms and conditions upon which the property of the cooperative is to be let, leased, or sold, and to make, revoke, and alter, and at all times enforce as it thinks fit such terms and conditions. D. Appoint and remove all solicitors, architects, surveyors, and employees. E. Appoint and remove managing agents, and to determine from time to time their remuneration and the terms and conditions upon which the managing agents are to act on behalf of the cooperative. And that is followed by subparagraphs F to I, which contain some further powers. Mr. Manning's argument can, I think, be summarised as follows. Step 1. Rule 30, although it uses the word discuss, is to be understood as meaning that it is the function of the members of general meeting to decide all management decisions. Step 2. Rule 69 therefore does not empower the committee to decide anything which is entrusted by the rules to the general meeting. That means that the committee cannot decide anything which is properly to be characterised as a management decision. Step 3. The rules therefore do require all management decisions to be taken by the members in general meeting, and hence the rules satisfy a statutory requirement in paragraph 2b of Schedule 14 to the 2004 Act. These submissions were skillfully advanced, but I do not consider that either Step 1 or Step 2 is well-founded. Taking first the meaning of Rule 30, what the judge said in her decision at paragraph 42 was that as a matter of ordinary language, to discuss is not the same as to decide. Where the rules wish to talk about deciding, they do so explicitly. And then she gives some examples. If the rules wanted the general meeting to take management decisions, it would have said so. This is not, as Mr. Manning suggested, a purely semantic point. It is about the plain meaning of words. As for the subject matter of those discussions, decisions that have arisen since the last general meeting is not the clearest way of putting things, but it seems to me to mean that the general meeting is to discuss management decisions that have been made by the committee since the last general meeting, not to make decisions on issues or problems of the like that have arisen since the last general meeting and now have to be decided upon. It may also mean discussion of management issues that have arisen and have not yet been decided since the last meeting, but Rule 30 provides for the general meeting to discuss them, not to decide. Mr. Manning took issue with that. He relied on numerous indications in the rules that general meetings are intended to be more than just a discussion forum or talking shop, and in particular are intended to make decisions. This requires looking at some of the other rules. The rules provide for two types of general meeting. Rule 21 providing that the cooperative shall meet in general meetings, which will be either an annual general meeting or an ordinary general meeting. The business of annual general meetings is set out in Rule 28, and they include A. Receiving the accounts, B. Receiving a report on the state of affairs of the cooperative, C. Electing the committee for the coming year, D. Deciding the frequency of ordinary general meetings, E. Appointing the auditor, and F. Quotes, consider any other resolutions relating to the business of the cooperative, which have been included in the notice convening the meeting. So far as ordinary general meetings are concerned, Rules 29 and 30 provide as follows. Ordinary general meetings shall be held at such times as may be decided by the cooperative at its annual general meeting or convened as provided for under the rules titled Provisions Applicable to Convening Ordinary General Meetings, and Rule 30 I have already set out and provides that the functions of ordinary general meetings as to discuss management decisions that have arisen since the last general meeting. The other rules which we were referred to include Rule 23, which provides that each notice convening a general meeting shall state which type of general meeting is being convened, the date, time and place of the meeting and the business to be transacted at the meeting. Rule 24, which provides that proceedings at a general meeting shall not be invalidated by reason of accidental omission to send notice of the meeting to a member, or by non-receipt of such notice to a member. Rule 25, which provides that each member shall be entitled to attend and vote at a general meeting. Rule 34, which provides that the only business which will be transacted at a general meeting is that mentioned in the notice convening the meeting and any business raised at the meeting by the present members. And Rule 39, which provides that every adjourned meeting should be deemed a continuation of the original meeting, and any resolution passed at the adjourned meeting shall for all purposes be treated as having been passed on the date on which it was in fact passed and shall not be deemed to have been passed on any earlier date. I accept, as Mr. Manning submitted, that these rules taken together do contemplate members not simply talking about things, but taking decisions at general meetings. The rules make express provision for some decisions, including the election of the committee, to be made at the AGM, as I read from Rule 28, and others are specifically referred to elsewhere in the rules. For example, Rule 17, which deals with expulsion, provides that a member may be expelled by a resolution carried by the votes of 2/3 of the members present and voting at a general meeting of the cooperative. Rule 96, which deals with appointment of the auditor, provides that every appointment of an auditor other than the first shall be made by resolution of the cooperative at a general meeting. Rule 119, which deals with changing the rules, provides that any rule of the cooperative containing these rules may be rescinded or amended, or a new rule may be made by a resolution carried by 2/3 of the votes given on the resolution to amend these rules at any general meeting. It may well be that over and above that, members in the general meeting can pass resolutions expressing their views on the cooperative's business. It may be that they can even give binding directions to the committee as they think fit. That, I think, is open to some doubt, as the Rule 48, as I read, provides that the management committee shall control and direct the management of the day-to-day business of the cooperative. And Rule 69, I think, goes further in referring to the business of the cooperative being conducted by a committee, and the committee being able to exercise all powers as may be exercised by the cooperative, which are not required to be exercised in general meeting. By analogy with some decisions in relation to companies, the effect of those rules may be that so long as the committee remains in office, members in general meeting cannot tell the committee how it is to exercise its powers. They either have to remove the committee or pass a special resolution altering the rules. But we have not heard any argument on that point, and I will assume that it would be competent for members in general meeting to give binding directions to the committee. Nevertheless, that is not enough for Mr. Manning's purposes. He needs to establish that the rules require that all management decisions are to be made by members in general meeting. That effectively means reading discuss in Rule 30 as if it said discuss and decide to the exclusion of the committee all management decisions. I agree with the judge that is simply not what it says. On the face of it, it says that the function of general meetings is to discuss all management decisions. The word discuss is an unusual one in the context. The normal meaning of it is undoubtedly to talk about something. The rule naturally reads as if the function of the general meeting is to review the decisions that have been made since the last general meeting and express views on them. I accept that, as the judge said, it may also contemplate a discussion of issues that have yet to be decided on. But it cannot, I think, be read as meaning that it is the function of a general meeting to decide, to the exclusion of the committee, all management decisions. That, as I've said, is simply not what it says. That conclusion is fatal to Mr. Manning's argument, but I do not think step 2 is well-founded either. Looking at Rule 69, it is not drafted on the basis that management decisions are to be made by the general meeting, leaving only their implementation to the committee. Evidence was given before the first-year tribunal by Mr. Alex Pridmore, Chief Executive of H35, and among other things, he said this: paragraph 29 of his witness statement. The committee actions decisions made at the general meetings and have discretion to make minor operational decisions. Examples of operational decisions include ordering stationery for the office, chasing members for licence fees, serving warning notices for breaches of the licence agreements, and making payments in line with agreed contracts, issuing notices for the meetings, collecting the data for the meetings, signing the licence agreements, room checks, to name a few. Any decision that does not relate to the day-to-day operations of society would be put to a general meeting. Examples of these include taking a lease of a new property, entering into contracts with utilities providers, accepting new members to the society, terminating members' licence agreements, instructing contractors, and instructing consultants. The FTT accepted his evidence, but the question, as accepted by Mr. Manning before us, is not what is done in practice, but what the rules provide. They seem to me plainly to provide that the committee does have power to make decisions on these matters, not just to implement decisions made by the members in general meeting. Mr. Manning was reluctant to be drawn on precisely which decisions would count as management decisions, saying that that was not something where a list could be drawn up in the abstract, but had to be decided on a case-by-case basis. He did, however, accept that a decision to buy a property would be a major management decision, not just a day-to-day matter. But Rule 69, to my mind, clearly contemplates such decisions being ones that can be made by the committee. As I read, Rule 69 sets out a list of things in particular that the committee has power to do, and the very first one is to purchase property. That list also includes a number of the other things which Mr. Pridmore, in his evidence, had referred to as not being operational day-to-day matters, but matters that he said would be put to a general meeting. I have no reason to doubt his evidence, which I've said was accepted by the FTT, but it does seem absurd for Rule 69 to set out and list a whole raft of powers which, without prejudice to their general powers the committee may exercise, if what it meant was that all these things were to be decided by the members in general meeting, and that the committee had no power to make any decision on these matters, but only to implement decisions that had already been made. In addition to that, there are various other specific rules which confer specific powers on the committee. Rule 12, which deals with admission to membership, provides that the committee may, within their absolute discretion and in accordance with the procedure which may be laid down from time to time by the Co-operative and General Meeting, admit or refuse to admit any person to membership of the Co-operative, save that such person must be a licensee or prospective licensee of the Co-operative. Rule 13 provides that every application for membership shall be made to the committee, and that it is for the committee to consider any membership application, and if it is approved, the applicant shall be required to forward the sum of £1. Rule 15, which deals with termination of membership, includes 15E, which provides that a member shall cease to be a member if there are a resident in housing provided or managed by the Co-operative and in the opinion of the committee are in material or serious breach of their licence agreement. And Rule 15G3 provides that a member shall cease to be a member if they are a prospective licensee and have and little 3 are reasonably deemed by the committee to have no real and present prospect of being offered a licence of a home in a property owned or managed by the Co-operative within the following 12 months. These, I think, are all fairly significant decisions and would naturally fall to be characterised as management decisions. There was some discussion before us about the purpose of the exemption in paragraph 2b of Schedule 14. What the judge said on that in her decision at paragraph 7 is as follows. The point of paragraph 2b is obvious. Where a building that would otherwise be an HMO is managed or controlled by a body of which the residents are all members with equal voting rights on all management decisions, then there is no need for that body to be regulated in order to protect its members from their manager. They manage themselves and can protect themselves. The exemption applies whether the cooperative society manages and controls just the building in question or, as in the present appeal, a number of buildings, provided that only and all the residents in the buildings are themselves the decision makers. In the light of a view I've come to, it's not necessary to reach any conclusion on this, but that seems to me to be right. Part 2 of the 2004 Act is about the management of properties, and paragraph 2b itself begins by referring to a building where the person managing or having control of it, that is, managing the building. The purpose of that, I think, is a very practical one, to see that properties are managed properly, involving things like doing repairs to the property and the like. The purpose of requiring HMOs to be licensed in Part 2 is presumably to improve the standard of management of properties. But one can understand that if all the people occupying a property manage it themselves, there is no need to regulate them. They are analogous to owner-occupiers who can be left to look after themselves. That is not necessarily the case if the occupiers do not run it themselves, but it is managed by someone else. And that seems to me to apply to a case of a committee who may or may not be responsive to the needs and wishes of the occupiers. Whether that is so or not, I am of the clear view that the judge was right, that the rules of H35 are not such as to require that all management decisions of society are made by the members in general meeting. That means, as the judge said, that the two properties in question were not exempted from being licensed as HMOs by paragraph 2b of Schedule 14 to the 2004 Act. Those were the reasons why I agreed that the appeal should be dismissed.
Thank you. Lord?
I agree with the reasons given by Lord Justice Nugee for dismissing the appeal.
I also agree. Mr. Lane, Notwithstanding that the appeal has been dismissed, I think you're bound by the order made by Lady Justice Cooke on the 18th of March.
Absolutely, there's no cost provision in this matter. The only question in terms of the order, apart from the office appeal dismissed, is whether there needs to be anything that, as happened in the original appeal, before Upper Tribunal Judge Cooke, formally remitting the matter back to the first tier tribunal to deal with the grounds 2 to 8.
I don't think that's necessary.
So be it.
None of us do. Anything? You've no observations about that?
No, only that I would have submitted that it wasn't necessary, and I know on a practical basis that the first tier tribunal has been in contact with those instructing me, asking for information when this appeal is decided, which will be given, and therefore they will continue with the arrangements for the rest of the appeal to be dealt with.
Thank you very much indeed. Very well then, thank you all very much indeed. Mr Manning, thank you again for your very skillful and helpful submissions, and Mr Lane, you and Mr Olive Harris' endeavours were not wasted in that we have of course read and found extremely valuable your written materials. So, thank you all very much indeed. Oh, yes, you'll see a transcript in due course.